There we go. Okay. So we're talking about the bureaucracy. One component of the bureaucracy is the cabinet. So understanding that the cabinet is made up of 15 departments, the heads of the cabinet departments are called secretaries. They all advise the president on their particular area of expertise. Hello, Nicole. And so, like Pete Buttigieg is the Secretary of Transportation. Deb Haaland is the Secretary of the Interior. So when Biden wants to make policy that affects either of those areas, they really involve, Buttigieg and Haaland in the decision-making process, and they advise the president as to what their department feels is needed for the country. And then hopefully, with the bureaucracy's part in the Iron Triangle, they will ask Congress for that legislation that they feel is needed to put into place. And if the legislation is already there, they'll ask Congress for the support in executing that legislation. So do you have to know that there's 15 parts of the department? I mean, that might be a smart idea, right? They're all secretaries with the exception of the Department of Justice. That person is the Attorney General. And, just like ambassadors and federal judges, they just require a simple majority vote of confirmation in the Senate. And on occasion, they will go or end up being at odds with the president because they realize that they're in, their own little world, and the president has many other worlds besides, interior transportation, if we're going to keep with our example. So on occasion, Haaland might not be 100% on the same page as Biden, and that can result in Haaland doing something called going native, which means that she becomes more loyal to her department than the president, and that can result in her getting fired. Just FYI. The cabinet does utilize greater levels of congressional oversight than other offices or other parts of the bureaucracy, specifically when compared to the executive office of the president. So let's talk about the EOP. The EOP is made up of a lot of positions, and it didn't always exist. Cabinet came into being before the executive office of the president did, because Washington realized, wow, I'm a military expert. I don't have an expertise in treasury or in foreign nations. So he had some of his buddies advise him in those areas. You remember, Thomas Jefferson, Secretary of State, Alexander Hamilton, Secretary of Treasury. But FDR realized that he needed a little bit more support, especially when he was dealing with the Great Depression and World War II. So the executive office of the president was created by him, and it now includes a lot of people, as many as 4,000 individuals. And it includes groups like the National Council of Economic Advisors and the National Security Council, as well as the Office of Management and Budget. Presidents can add to it or take away from it where they see fit. For example, Biden added the Council on Gender Policy to make sure that, he's coming up with policies that are non-discriminatory and more inclusive of the LGBTQ plus community. If there is a conservative who is elected to president coming up soon, chances are they may not keep that office. You see what I'm saying? Anyway, so the EOP is really more loyal to the president. Not all of them need to be confirmed by the Senate, and they do not have near as much congressional oversight. They really just work with the president. So that's the EOP. The other parts of the bureaucracies besides the cabinet and the EOP are the White House staff, and those are just people who work with the president on a daily basis, like the chief of staff, the press secretary, those sorts of folks. And they do not require Senate confirmation. The president can hire and fire at will, and those can be his, like best buddies. If you wanted to think of the spoils system under Andrew Jackson, you probably still see that more on the White House staff and ambassador appointments, by the way. Finally, you've got all those independent agencies, right? So independent executive agencies who don't exactly fit with the cabinet department, like NASA. So they're an independent executive agency. Independent regulatory commissions. They all end in the word commission. They regulate some aspect of the economy, like the Equal Employment Opportunity Commission, the Securities and Exchange Commission, the Federal Communications Commission. And some of those heads do need to be required or do require Senate confirmation as well, because they're such a big deal. And then you've got those government corporations, right? Like the UPS, like Amtrak, like the Tennessee Valley Authority, which, yes, is still a thing. And so all of those groups make up the bureaucracy, a really complex, large organization that does create rules that do have the same force of law. So when the legislative branch makes laws, the executive branch executes laws. The bureaucracy let's just take the ADA, for example. Not the ADA, I'm sorry. The FDA, for example, will take that piece of legislation and they'll determine how to implement it through bureaucratic discretion. So what sort of regulations do we need to make in order to make sure that people are following the laws in the way that Congress intended? And so that's part of that role that they play in that iron triangle that includes Congress, bureaucracies, and interest groups. The bureaucratic agency is just there for Congress implement the laws in the way that they want, and for interest groups in a very similar way, allow for regulations that are favorable to members of those interest groups. So some people call them the fourth branch of government. Don't do that. They're in the executive branch, right? So let's not make that mistake. Hannah, I know that was pretty long-winded. Did that answer your question?
Yes, it did. Thank you.
Sure. Did anybody have a question about anything that I just said during that whole super long spiel? Okay, well, what are some other questions we can come up with? And like I said, you can put it in the chat. If I can figure out, if I remember how to find the chat, I'm guessing it would just pop up if anybody had anything to say, or we can just come off mute and ask questions too. Yes, the significance and specificity of the iron triangle. Okay, yeah, let's talk about the iron triangle a little bit more, because it's a pretty important concept that you will definitely see on there. So the iron triangle is given that name because it is so strong. Just think iron is a very strong metal, and the long-term stability of the relationships that exist between the three participants of the iron triangle, the interest groups, a portion of Congress, and then a portion of the bureaucracy. So if you wanted, we could talk about veterans, and we could go with the part of the bureaucracy, the Department of Veterans Affairs, the Congressional Committee on Veterans Affairs, and then any number of the interest groups that exist for veterans, disabled American veterans, wounded warriors, so on and so forth. So there was recently legislation that passed in Congress to provide some additional insurance for veterans who were victims of burn pits, I believe, when they were fighting in Afghanistan, if memory serves correctly. So the triangle exists to develop mutually beneficial public policies. So that's something that iron triangle probably pushed for to see happen. So various interest groups identified for their members, which are veterans, that they were dealing with specific health problems caused by that issue, caused by exposure to burn pits. And so they wanted, since the federal government does offer veterans benefits as an example of entitlement benefits, mandatory spending, they wanted to up those benefits for those victims specifically. So those interest groups would lobby Congress for that policy. In fact, it makes sense to me that they actually had some of their groups write that legislation for then one of those members of the Congressional Committee on Veterans Affairs, whoever that might be in Congress, to propose it. So that's what the interest group does for that portion of the iron triangle, is that they will donate to candidates who are seeking office for, representative or senator, and say, listen, we support you because we know you will support us. We understand that we both are looking for the same thing here. And then, those members of Congress, because of that established relationship, they're going to try to pass that policy that interest group wants, right? I hope that makes sense with that specific, you scratch my back, I'll scratch your back, for that portion of the iron triangle. And then the Department of Veterans Affairs would figure out how to identify those veterans that struggle specifically with that health problem, and how to ensure that they get those benefits, perhaps by better equipping VA hospitals with some more resources, things like that. And ensuring that if some veterans are not getting those benefits, how do we punish individuals who are making sure that that's not happening? Like if they're not helping them get those benefits. I don't know, if a VA hospital is not being compliant or something along those lines. So again, the bureaucracy in the iron triangle will have favorable implementation for Congress for the laws that they pass, and Congress will give them favorable oversight, like more money to accomplish what they need to accomplish. And, those interest groups will lobby on the bureaucracy's behalf to Congress to get those things that will make everybody happy. I hope that helped to my person who sent me my private message. Okay, what else can we talk about? And again, you can totally put it in the chat. You can come off mute and ask a question. I will tell you this while you guys are deciding whether or not you want to come off mute. Remember, issue networks are, and Allison, I see your question. I'll get to that. Thank you, sweetie. Issue networks are kind of that more informal thing that you could compare to an iron triangle. They have way more people, multiple lobbyists. The media can be parts of issue networks. Individual members of Congress and bureaucrats can be parts of issue networks, lots of interest groups. And typically they form around more narrow issues than the iron triangle does. So let's say there's an iron triangle that exists with agriculture. So the House and Senate committees on agriculture, the U.S. Department of Agriculture, and interest groups for farmers. An issue network might just focus on like a particular part of pesticides and food production. And once what they're looking for has been accomplished through a piece of legislation in Congress, then they'll dissolve. They're shorter in terms of duration. But they both kind of exemplify pluralism. This idea that there's so many groups out there who are advocating to be a part of the policy agenda. So there's participation of numerous groups. So typically we're going to have to compromise and produce policies that, more than one group wants, and one's not going to rise up and completely dominate over the other. However, sometimes those interest groups that are larger in size and larger in resources, that does translate to more political power, and they can have a little bit more influence on policy outcomes. Okay. Some problems with the iron triangle. Sometimes people point to the revolving door when people leave Congress and then go back in as lobbyists. And that's just like people moving around on the iron triangle in a different group. So sometimes people point to that and saying, that's just involving a small group of people making policy, and that's not just the best for our country. Maybe we need to have some
Recording in progress
involved. Ooh, something's in progress. Okay. All right. And I'm letting in some other people. All righty. I was asked to review Unit 3 in general and selective incorporation. Sure. Let's do it. We did a lot of that in class on Friday. So Allison, I know, and Neil, you want to go over the major cases. So yes, we can do that. And I'll do it briefly and kind of give you an idea of some things that I would, if I were you. When looking at Unit 3, guys, the focus is on civil rights and civil liberties. Excuse me. Just know that civil rights are protections from the government against individuals who are being discriminatory, or against governments like state governments who are being discriminatory. Yes, I can do a brief description of Federalist Papers in just a minute. So civil liberties are found in the Bill of Rights. Okay. So when we're thinking of civil rights, I want you to think of the Civil Rights Movement. I want you to think of the Civil Rights Act. And I would know the Civil Rights Act, guys. I would know that it was passed in 1964. Will you have to, would they ask you that date in a multiple choice question? Of course not, because that's silly. But just in terms of historical context, it's helpful. So I would know that in 1964, because remember, it was passed in large part because of JFK's assassination. LBJ was able to use that as political leverage. And it did many things, including codify Brown, right? Brown v. Board of Education was determined in 1954, but since the Supreme Court lacks an enforcement mechanism, as we learn in Federalist 78, which helps make them the least dangerous branch, they don't have the power of the purse like Congress. They don't have the power of sword like the executive branch. They just have the power of judicial review, and they rely on other branches to enforce their decisions. So that can be kind of challenging, especially when there's such serious pushback from an unpopular decision when the states don't want to comply. So the Civil Rights Act did say that all schools were integrated now, that there could be no segregation, no discrimination based on race, color, national origin, religion. They also said that there can't be employment discrimination, right, in terms of any of those things, but it also included sex. And they said there could be no discrimination in public places based on those categories as well, those demographic categories. So that was the Civil Rights Act of 1964. The Voting Rights Act of 1965 had the effect of really increasing voter turnout. That would be a nice connection for you to make on an FRQ if you had the opportunity, because so many Southern states were, putting into place literacy tests and no longer poll taxes after the 24th Amendment. And not grandfather clauses as much anymore, but just in general, lots of things that got in the way of enabling African Americans to carry out their suffrage as guaranteed to them by the 15th Amendment for African American males and by the 19th Amendment for females. It was just a problem. So that's what the Voting Rights Act did. And that was what created that pre-clearance stuff we talked about, where if Southern states wanted to change their voting laws, they needed to get pre-clearance from the federal government, which is why in Shaw v. Reno, North Carolina, proposed that majority minority district. And Janet Reno, the attorney general at the time, said, no, you need another majority minority district to increase representation of your large African-American population in your state that has no representation in Congress. So the North Carolina legislature said, sure, we'll comply with that. So that's an example of pre-clearance. And then remember what happened with Shaw v. Reno. A white citizen, Ruth Shaw, said that they experienced discrimination as the white citizens were segregated based on race out of their district. It was racial gerrymandering, which they claimed was a violation of the 14th Amendment Equal Protection Clause, and they won. They won. So when you're talking about civil rights, please, please, please make sure that you're referencing the Equal Protection Clause. And the three cases that I would know for civil rights are Brown v. Board of Education, school integration, right? Baker v. Carr, which wasn't necessarily racial gerrymandering. I mean, it was, but the Supreme Court looked at the overall issue as malapportionment, that one person's political voice did not weigh the same as another person's political voice in another smaller district, right? So Baker v. Carr was important because it established that gerrymandering cases could be justiciable, meaning the Supreme Court could weigh in on them. Justiciable. I know that's kind of an interesting word, but it is what it is. And so, yeah, Baker won, right? Tennessee, which hadn't redrawn their district lines in 60 years, even though they're supposed to every 10, did have to redraw those lines. And that laid the groundwork for other gerrymandering cases later on involving compactness and contiguous districts. So that's civil rights. And then in terms of civil liberties, remember, there's all those things that are listed in the Bill of Rights. So if I were you, I would really study Amendment 1, 2, 4. I'd know a little bit about 5, 6, maybe 8, definitely 10. Guys, I don't think they're going to ask you about Amendment 9, because typically when we think about civil rights in Amendment 9, that's unenumerated rights, or civil liberties, excuse me, and Amendment 9, that's unenumerated rights. So it's stuff that's not listed. And typically, from our required court cases, that would make you think of Roe v. Wade. Well, guess what? Roe's not going to be on there. So if they do ask you privacy, they might ask you about marital privacy, Griswold v. Connecticut, but I doubt it. I doubt it. But I've been wrong before. I could be wrong again. Hi, Maggie. Hey, old girl. Anyway, okay. So I would know which case is associated with which amendment. And I know we did this in class on Friday, but we've got some people here from the fall semester. So I'm going to run through this really quickly. I'm going to time myself. For the First Amendment, if I were you, I would know the speech cases. I would know Schenck. I would know Citizens. I would know Tinker. And I would know that Schenck is a good example of judicial restraint because they upheld the Espionage Act. And I would know for Schenck the clear and present danger test, which has been extended to include imminent lawless action. Your free speech is not absolute. I would know for Tinker it's symbolic speech. Remember those students with the black armbands to school protesting the Vietnam War? And they won. Tinker won because it was not disruptive activity, and students do not shed their rights at the schoolhouse gate. If I were you, I would know symbolic speech for that. And then for Citizens United, it's been the case the last 2 years. I will be floored if it's the case this year. Absolutely floored. For SCOTUS case comparison, FRQ. But Citizens United, this group, which had money, in part from corporations, wanted to air an election ad right before the campaign. They're not allowed to do that because they use money from their general treasury and thus unlimited amounts of money. And the Bipartisan Campaign Reform Act was trying to level the playing field in terms of political advertising, with more groups with more money not being able to influence elections so quickly or so close to the election. Anyway, they claimed that the laws interfered with their free speech. They won. So that's political speech. I would not. So political speech. So spending money equals political speech. That's freedom of expression protected by the First Amendment. So Citizens United won. I would know for religion, the Establishment Clause and Free Exercise Clause, right? Establishment, Congress cannot establish any religion. There's no prayer in school. And that, of course, is the case Engel v. Vitale. And I would know free exercise, Wisconsin v. Yoder. The Amish didn't want their kids to go to school when Wisconsin compulsory education laws said they had to go to school. So they took them out, got in trouble. Let Maggie in, I'm sorry. And yeah, that law impaired with their free exercise of religion. And so the Amish won. And then free press is New York Times Co. v. US. The Pentagon Papers case, when the federal government tried to prohibit the New York Times from publishing any further information using prior restraint, the Supreme Court said, no, you claiming this is a national security issue is a bunch of bull. And you just got in a lie and you're trying to cover your own rear. So this established a precedent that if the government is going to use censorship of the media, which, hello, freedom of the press, First Amendment, then they have to, there's a heavy burden of proof on their part. I would know for Amendment 2, individual right to bear arms. I would know McDonald v. Chicago. And I would know that's a selective incorporation case. So if selective incorporation always confuses you, here's what you need to know. It all comes down to the 14th Amendment. The Bill of Rights protect us from the federal government encroaching on our civil liberties. However, and in Amendment 5, it says the federal government cannot take away any of your rights to life, liberty, or property without due process of law. But then the 14th Amendment, following the Civil War to keep Southern states in check, said no state can deny a person their life, liberty, or property without due process of law. So there's two due process clauses, but it's the due process clause of the 14th Amendment that makes people say, well, then if a state can't deny my liberty, why can't I have free speech? Why can't I, as an individual, have the right to bear arms? Why can't I have the right to a lawyer? You see what I'm saying? So it's the 14th Amendment due process clause that starts the process of selective incorporation, of extending those protections in the Bill of Rights from encroachment by the federal government to also apply to state governments. States can't encroach on our liberties either. So that's selective incorporation. And it's important to know that for the Second Amendment with McDonald v. Chicago, it incorporated the Second Amendment to the states, the individual right to bear arms. So Chicago's gun law that kept Otis McDonald from registering a new handgun was unconstitutional. And then if you guys remember for the Sixth Amendment, Gideon v. Wainwright, it had the same effect. It incorporated the right to counsel to the states as well. Let's see. For the Fourth Amendment, I would know the exclusionary rule. We don't have a case on that, but evidence can't be used in a court of law if it's obtained without a warrant. It can be excluded. For the Fifth Amendment, even though Miranda versus Arizona is not a required case, I would still know it because it's all about the right to remain silent and, protecting the rights of the accused. That was a Warren court case, judicial activism. And then I just went over Gideon. I think that's it. Oh, and then the other cases that you need to know, wrapping this up, because this can be long-winded, are the ones from Article 1 and Article 3 with the clauses, right? So for the necessary and proper clause, I would know McCulloch v. Maryland, where Maryland was trying to tax the National Bank because they didn't like it, and they were trying to push them out. And James McCullough, the cashier, refused to pay the tax that Maryland placed on the bank. So first, the Supreme Court had to determine if the bank was constitutional, and they found, according to the necessary and proper clause under implied powers, it was. And then if it's constitutional, can the state tax it? No, they can't because of the supremacy clause. So I know that. And then I would know judicial review, Article 3 from Marbury versus Madison. And guys, if you want a refresher on Marbury versus Madison, I would watch a video on it. I really would. I think that would be a good idea. I would watch the Bill of Rights Institute. They have a really good one. And it just kind of goes over how, in that case, John Marshall finally, well, not finally, but declared a law that Congress passed to be unconstitutional, solidifying judicial review and making the Supreme Court a co-equal branch of government. All right. So Allison, I hope that helped. All right. I'm going to the chat because I've got some questions here. And that was all the major cases. So I hope that helped. Neil, can I do a brief description of each of the Federalist Papers, what you need to know? Yes. Yes, I can. So remember, Federalist Paper 10, fact 10s, right? James Madison said a large republic is best suited at being able to fight the ill effects of factions. They said, listen, factions are going to develop. That's just no way around it. Groups of people are going to come together with their own ideas and they're going to be competing. That's the nature of a republic. And we have a large republic. However, by allowing everybody a voice and by allowing everybody liberty, all of these factions are going to be competing against each other. One is not going to rise up and take control. So that's the best way that we can guard against majority tyranny. So that's Federalist 10. And Federalist 51, Madison talks about the double security for the people. The double security comes from division of government and then separation of powers. And then once you have that separation of powers, checks and balances. So remember, division of government is federalism, right? It's the division of all of the power that the government has between the national government, state governments, and then, of course, local. Don't forget about them. They matter. And so you are protected, your rights are protected from the federal government and from state governments, right? And then we have to separate the power at both levels. So there's an executive, a legislative, and judicial branch at the federal level and within all of the states. And they each specialize in their own area. The legislative branch makes laws, the executive branch executes laws, the judicial branch interprets laws. And then through the system of checks and balances, we have ambition to counteract ambition, to make sure that no one group becomes too powerful and they stay where they're supposed to stay. So that's Federalist 51, both Madison, both 10 and 51 are Madison. 70 and 78 are Hamilton. And 70 is that energetic executive, right? That Hamilton is trying to calm the anti-federalists and Brutus I's fears that the president is going to become a king. No, they're not. No, they're not. They're going to be very energetic, which we want to have. We want an energetic leader who's able to deal with problems when they arise, like, oh, I don't know, Shays Rebellion. And then case in point, Washington with the Whiskey Rebellion, right? But he said, it's important for this executive to be energetic, to deal with crisis immediately and to respond well, but they also need to be singular, because if they're singular, if they do something wrong, we know who to blame. If they're singular, they're going to be able to make decisions quickly without conferring with the council. If they're singular, there's not going to be infighting. If they're singular, one group isn't going to rise up against the other group and try to take over, causing civil war. So that's Federalist 70. And then Federalist 78, that's the part that says the judiciary is the least dangerous branch, that judges are going to be impartial. They're going to focus on their interpretation of the Constitution. They're going to use judicial philosophy that they deem as appropriate. They're politically insulated through lifetime tenure and being appointed, not elected. And the fact that Congress can't lower their pay raise. And they have no enforcement mechanism, nor can they initiate anything. So they're not going to like come after anybody. They're the least dangerous branch. We don't need to be concerned about them. And then finally, Brutus I, he just talks about how bad the Constitution is. Like he just slams it the whole time. He just hates on it. He says it's way too strong. The Articles of Confederation just had a hiccup, and we just need to fix them rather than scrapping and starting over, because this new strong government, because of the necessary and proper clause, will be able to do things that they don't say they can do in the Constitution. Because of the supremacy clause, is going to dominate anything that the state wants to do. because of the national judiciary, which the articles did not have, they're going to, go over the state decisions anytime they feel they need to. Because of the power to tax, that's the power to destroy, essentially. And so there's going to be no money that the people have left to give to their state governments for revenue through taxation. And the president's going to become a king. That's just ridiculous. That's ridiculous. Also, states should be able to control their own trading stuff with each other and not the federal government. So he just hates on it. I hope that helped, Olivia. Does anybody have a question about any of those Federalist Papers or Brutus one? Okay. More questions in the chat. Can I review the difference between activism and restraint? Yes, I can. If you're looking for an example of judicial restraint, I want you to cite Schenck. Okay, I really do, because judicial restraint means that the court is less likely to overturn law or policy from the legislative or executive branches. They're going to defer to them as their elected officials, and they're going to use just more of a, oh gosh, that's a really large lizard. Sorry. They're just going to use more of a like conservative approach to making huge changes, not conservative in terms of ideology, just like less. In terms of judicial activism, sometimes they believe that on the bench, they have the opportunity to right the wrongs that elected officials do. Maybe they felt those elected bodies were bending too much to the whims of the public, and they went outside of what the Constitution gives them the power to do. So judicial activism, sometimes they will overturn congressional law. A good example of that might be U.S. v. Lopez, where they determined that that Congress acted outside of the Commerce Clause. They should not have passed the Gun-Free School Zones Act under the guise of saying it dealt with interstate commerce, because it didn't. Another example of judicial activism, Brown v. Board of Education, in striking down their own precedent, which is an example of activism, which was Plessy versus Ferguson, and then establishing national policy that the entire United States have to follow. That is a huge judicial activist case. Most of the cases we looked at, in fact, almost all of the cases we looked at were activist cases. So I hope that helps, Isabella. Let's see here. Can I talk and explain the 3-tier court system? Yes, I can. And can I talk about a couple of the amendments from the executive branch? Yes, I can. All right, so the 3-tier court system is established in the Judiciary Act of 1789, which is the same Judiciary Act that part of Marbury versus Madison declared unconstitutional. The part that Marbury versus Madison declared unconstitutional was when Congress said that the Supreme Court had the power to issue writs of mandamus, requiring members of the government to do something. That was the part that they said was unconstitutional, FYI. But it did establish a 3-tier court system. So Article 3 is really quick, short, and vague. It only establishes the Supreme Court, but in Article 1, it says that Congress can create lower courts. Excuse me. So that's an express power of Congress, by the way, since it's in the Constitution. And so in the Judiciary Act of 1789, they created our 3-tier court system that we have today. District courts at the bottom, which hear the vast majority of original jurisdiction cases for the federal government. If somebody breaks a federal law, you're going to have your case heard in a federal district court, and we have one in Atlanta. There's 94 district courts, just FYI, throughout the United States. We have 3 in Georgia. The next level is the appellate courts, and they're divided based on geography. We have circuits. We're in Circuit 11 with Florida and Alabama. And we do have an appellate court in Georgia, again, in Atlanta. And those cases are heard by a 3-tier panel. At a federal court, they're heard by a judge and a jury. But at the appellate court, just 3 judges on a panel. And they only have appellate jurisdiction, meaning a district court already heard the case, and now the appellate court is considering the case. And they act as kind of the gatekeeper for the Supreme Court, because between 7,000 and 8,000 cases try to make it to the Supreme Court every year, but they only hear around 70 or 80 cases because, there's only 9 of them. That would be a lot. So, I mean, typically if a case appeals to go to the Supreme Courts, they will not issue a writ of certiorari in order to send the case up. Instead, they will just say stare decisis and the decision stands. Okay. Meaning they won't consider it. So that's our three-tier court system. I hope that helps. The Supreme Court has mostly appellate jurisdiction. On occasion, they have some original jurisdiction if it involves like a diplomat or something like that. And then I was asked if I would go over amendments from the executive branch. And yes, I will. So Amendment 12 is the amendment that separated the electoral vote to 2 votes. So let's remember Biden won a majority of the popular vote in Georgia for the election of 2020, which Georgia uses a winner take all system like most other states. Only 2, Maine and Nebraska, do not. They use proportional system. So the 16 Democratic Party electors got to go to the state capitol and cast their votes. And they each cast a vote for Biden. And then they each cast a vote for Kamala Harris. So it's 2 separate votes. That way we avoid that horrific runner-up system that we've had in the past. The 20th Amendment is known as the lame duck amendment. The lame duck period would be a great thing for you guys to reference in an FRQ if given the opportunity. And that just refers to that time period following midterm elections if a president is term limited. So like the last 2 years, or following the election if a president who is seeking re-election was not re-elected, like President Trump in 2020. And in that time period, they just lose their influence because members of Congress know that they don't have that strong political coattail effect anymore because somebody new is going to be coming in. And so Congress just kind of does what Congress wants to do. Unless, of course, it's an incredibly popular president. And then for re-election's sake, you want to be tied to that person. So the 20th Amendment lessened that lame duck period. It used to be that the new president wouldn't take office until like March. Now the president's term of office begins January 20th at noon, and Congress's new term of office begins January 3rd at noon. So Congress goes back to work before the president comes in, just FYI. The 22nd Amendment came after FDR, and it limited the president to 2 terms. Pretty much Washington just set the precedent of only seeking re-election once. Roosevelt tried to do something a little bit different, Teddy. And of course, FDR did something different. He was elected 4 times, but we realized, maybe that's a little too close to a monarchy. We want to get away from just having one person in this office for 12 years. That's a bit much. So the 22nd Amendment says you're limited to 2 terms or a max of 10 years if you take over for your predecessor in the middle of their term. And then the 25th Amendment has to do with presidential disability and the order of succession. So, we have a very old president. If something were to happen to President Biden, the order of succession says that Kamala Harris will become the new president. If Kamala Harris doesn't want the job, it then goes to the Speaker of the House, because the House is the truest representation of the American people, and they are the only body that was directly elected at the beginning of the nation. I think I might have cut out. After vice president, it goes to the Speaker of the House, the truest representation of the American people. Remember, at the beginning of the nation, they were the only people who were directly chosen at the federal level. If they're unable to be president because their qualifications are different, it goes to the president pro tempore of the Senate, skipping the president of the Senate because the president of the Senate is the vice president. And if the president tempore doesn't want the job, then it starts going to cabinet, starting with the Secretary of State, Treasury, Defense, so on and so forth, in order of creation. All right, so I hope that helped, Annika. Can I review the main committees that you need to know? Sure. So congressional committees, remember, can be a part of that iron triangle. So that's a good thing to know. And if I were you, I would know 3. I would know 3. I would know 2 from the House, and I know 1 from the I would know 4, excuse me. I would know 2 from the House. I would know 1 from the Senate. And then I would know 1 that involves both. So I would know the conference committee, because the conference committee is the committee that exists if the House passes a different version of a bill than the Senate. They've got to come together as one committee and iron out those differences, producing a compromise bill that both chambers can embrace and vote in favor of. So I would know conference. I would know for the House of Representatives, again, as a truest representation of the American people for many reasons. They're elected every 2 years. There's more of them. They're younger. Their qualifications are not as stringent. They represent districts. They were directly chosen by us. So remember the part of the Declaration of Independence that said no taxation without representation? The House of Representatives deals with taxation first before the Senate, and they do so in the House of Ways and Means Committee. So all bills regarding taxation originate there. Also, I would know the House Rules Committee, because every representative is going to want to propose multiple bills. And so that hopper that they put their bills in is going to be quite full. And so the House Rules Committee acts as a traffic cop to kind of manage the flow of bills, since so many are coming in at a time. And then, Brandon, I would know the Senate Judiciary Committee. They're the ones who consider all the federal judicial appointments. And remember, there's like 800 federal judges. So that's a lot. You've got to consider those people and decide if you think that they are a good fit. And on occasion, there's this thing called senatorial courtesy, where the other senators, if there is a vacancy for a federal judge in a state other than their own, will defer to their colleagues, like, oh, this person's good enough for you, then they're good enough for me. And the president will often ask senators, is there anybody that you know of that we think would be a good fit for this federal judge position? So yeah, I would know the Senate Judiciary Committee. I hope that was helpful. My next question, can I go over some of the most prevalent implied powers versus express powers? You bet. Okay. And guys, if while I'm going over stuff, you think of questions, you can send me direct messages or you can put them in the chat. All right. So just make sure you know, for express powers, they're also known as formal powers, enumerated powers. For the national government, they're known as delegated. And for states, they're known as reserved, although express powers specifically are powers mentioned in the Constitution. So reserved powers are not the same. I hope I didn't confuse anyone just there. So express powers of the president, let's go over a couple of those. In Article 2, it says that the president is the commander in chief. It says the president has the power to veto and pocket veto. It says the president has the power to give the State of the Union. It says the president has the power to appoint ambassadors and other, foreign dignitaries and diplomats and federal judges. So I hope that helps. Express powers for Congress, certainly the power to declare war, which has to be done by both chambers, simple majority vote. I would make sure that I know the power of taxation, the power to borrow, the power to coin money and regulate its value. Copyrights and patents are express powers of Congress. The power to maintain an army is an express power of Congress. The power to impeach is an express power for the House of Representatives. The power to remove is an express power for the Senate. So I would know those. Implied powers for the I need a sip of water. Hang on. Implied powers for Congress are derived from the necessary and proper clause. So the National Bank is a phenomenal example of implied powers, because implied powers help Congress do anything that helps them carry out their express powers. So the National Bank helps Congress, tax, borrow, spend, coin money, regulate its value. It's all very beneficial to those things. So that's a great example of being able to do something that's not in the Constitution that helps you carry out those express powers. So I would know those are derived from the necessary and proper clause, also known as the elastic clause, because it helps congressional power grow. I would know for the president, implied powers come from the executive power clause, which is that first line of Article 2. The executive power shall be vested in a president of the United States of America. All right. Well, what the heck is executive power? So the examples of implied powers for the president are those executive orders and executive agreements. Please, please, please do not get those confused. Executive agreements have the same force of treaties, but bypass the Senate. Did I say executive agreements? Executive agreements have the same force of treaties, but bypass the Senate. Executive orders have the same force of law, but bypass Congress. Now, since they're bypassing the legislative branch, they are temporary, and they will not go on unless the incoming president wants to carry them on. But typically, if funding is involved, many things do get carried on, and it doesn't have to be just from a Republican president to a Republican president. It can be from a Republican to a Democratic president. There are a few things that Biden has continued on that were Trump era executive orders. And then executive privilege is an example of that implied power. And that was limited through Nixon v. US when Nixon tried to say, I don't have to turn over audio conversations where I'm talking about illegal things. The Supreme Court goes, yeah, you do. So executive privilege does allow for the president to be privileged to certain information and to their closest advisors to be privileged to certain information. So like, especially that White House staff, if any of them are ever subpoenaed to testify in something, they can cite executive privilege as well. And then those signing statements, the president can sign something at the end of a bill where they say, I would veto this, but I can't veto this because you'll override my veto. So just know there's a caveat to me signing this. I don't plan on doing this sort of thing. They can't do that. So those are all implied powers. I hope that's helpful. Let's see here. Descriptions of types of polls. Okay. So you can have benchmark polls, which are taken to determine how well a person would do if they ran. Tracking polls that take place during a person's campaign, and typically horse race journalism can be a good example of tracking polls showing who's ahead of who. Exit polling data is taken as a person leaves a polling place where they reply who they voted for. And again, the media can play that, and that's very frustrating because people just typically pay attention to that and they don't know about actual things that matter, like where the candidates stand on issues. They just know about the drama of the election. So those are the polls that I would know, kiddo. Hang on, I've got more questions. Can I review the phases of presidential elections and congressional elections? Sure. So just know that for presidential elections and for congressional elections, you have the nominating portion and the general election. So a lot of the times we call the nominating portion the primary. So keep that in mind. And because of progressive reforms, things like the direct primary, caucuses, recalls, referendums, initiatives, direct election of senators came about, empowering the individual to have more of a say in our democracy. It used to be that parties chose the candidates without any input from us, but that was really bogus. So now when somebody decides that they want to run for president, so let's see, we've got RFK Jr., Marianne Williamson, and Joe Biden for the Democratic Party, and then coming up here in 2024. And then we've got Donald Trump, we've got DeSantis, we've got Nikki Haley and others for the Republican Party. In Georgia, we have an open primary, which means you can show up the day of and say, I'd like the Republican ballot or I'd like the Democratic ballot, and you get to choose between those people. That's the primary election. Some states, very few, offer an alternative to this. It's called caucuses, where only registered party members can participate, and they talk it out and they hash it out. In a primary, it's a private vote. It's an easy thing. But anyway, whoever wins the most votes in that state, for the Democrats, they'll get a proportion of that vote at the national convention. And for the Republicans, it's typically a winner take all system. And so the states weigh in to determine who they want the nominee for the party to be. So that's the nominating portion of the campaign. Okay. Following the national convention, it's the general election. And that's where it was Trump versus Biden. Or for Congress, that's where it was McCormick versus Christian for District 6. I hope that helps. Can I go over all the Latin you need to know? Sure. I would know habeas corpus. There's a few references to individual liberty that are in the Constitution specifically. That some of the Federalists cited to the Anti-Federalists when they said there was no protection of individual liberty. They said, habeas corpus, no bills of attainder, and no ex post facto laws. Habeas corpus means present the body. So if you are arrested and held in jail as being suspected of involved in a crime, at some point they've got to bring you before a judge and charge you with a crime. They can't just hold you forever. So that's habeas corpus, and that can't be suspended unless by a president during times of war, which we've seen. Bills of attainder is when you punish someone without a trial. So that's terrible. And ex post facto laws are where you punish someone after the fact. Like in Colorado, weed is legal. And then, all these people are going to dispensaries buying weed. Let's say that tomorrow they say weed is illegal. They can't go and knock on those people's doors and say, you bought weed when it's illegal, or when it was legal, you're going to jail. They can't do that. So that's one Latin phrase I would know. The others are typically associated with the judiciary. So if I were you, I would know stare decisis, which means let the decision stand. I would know a writ of cert or certiorari, C-E-R-T. That just is an order for the Supreme Court for a lower court to send up the information on the case. They're actually going to hear the case. I would know amicus curiae, or just amicus briefs. Those are filed by interest groups when the Supreme Court or any federal court is hearing a case and they want those judges to have information that their members want them to know that could help the justices make their decision in a way that the interest group members will find favorable. So I think that's the Latin phrases to know. Does anybody know another one that I'm forgetting? Okay. If you do, put it in the chat. All right. So I hope that was helpful, Sweet Pea. Ooh. Hey, something that we haven't talked about is the War Powers Act. I would know the War Powers Act if I were you. I would know it for a number of reasons. Number one, remember Brutus said that power that is willingly given up is very difficult to take back. Typically, it's taken back by force. And when Congress gave LBJ, through the Gulf of Tonkin Resolution, more power in terms of war making, he had it for the duration of his presidency, and then Nixon had it. So in 1973, Congress decided to take it back. So they passed the War Powers Resolution, which says that if the Congress commits troops or uses troops or in any sort of military operation, they need to let Congress know within 48 hours of deployment. And then they can be there for 60 days. If at that point Congress says we don't want them there anymore, they have 30 days to get their you-know-what together and come home. So the president can commit those troops for 60 to 90 days without congressional approval. Now, Nixon vetoed this. I mean, of course, Nixon did. The framers said that ambitious people are going to strive for political office. That's why we have checks and balances in place. And so he vetoed it. He said, absolutely not. I'm digging the power that I have in the War Powers Resolution. You can't, or in the Gulf of Tonkin Resolution. You can't take that from me. Congress overrode the veto. 2/3 vote. Only 3% of presidential vetoes are overridden. That's a really good one to know. And the War Powers Act today is tough to follow because typically when the president uses the military, typically it's popular. The American people like it because typically if they're using the military, it's to defend, democracy and liberty and our country. And we have that rally around the flag effect. And if a president is popular, then a president is going to have a lot more influence in Congress. So it's hard for Congress to say, I know that you did this and it's popular, but you didn't tell us. It wasn't nice. You see what I'm saying? Also, with technology, it's kind of challenging to know what counts as military deployment and what doesn't. Is a drone strike military deployment? You know what I'm saying? Anyway, so I would know the War Powers Act if I were you. What else can we go over, guys? We got a few more minutes. I can go over core values. That's a great thing to go over. So, guys, when we're talking about ideology, hear me. On an FRQ, if you're asked about ideology, the answer is liberal or conservative. If on an FRQ you're asked to tie ideology to Congress, then you need to make the connection that liberals are typically Democrats and conservatives are typically Republican. And it depends on what party is in control, which has the majority and thus more influence in terms of what legislation comes out of Congress. That's a great opportunity for you guys to reference divided government as well, right? Okay. And how divided government can typically result in gridlock. Okay. The core values. You've got individualism, this idea that you as an individual are responsible for the decisions you make and the situation you find yourself in. You have equality of opportunity, not equality of result, not economic equality, equality of opportunity, meaning everybody needs to be given the same opportunity to find the same success based on their own effort. Okay. You've got free enterprise, and that means limited government involvement in the economy. laissez-faire approach, right? As little government involvement in economic decisions and transactions between individuals and businesses. You've got rule of law. Everybody has to obey the laws, regardless of who you are. And then you've got limited government. I want you to think of liberties here. How much should the government be involved? How much government needs to exist to balance liberty versus order, right? Typically, conservatives tend to really value free enterprise, typically. And typically, liberals tend to really value equality of opportunity. For example, let's look at Obama and the Affordable Care Act. By making healthcare a public option and thus more affordable, he did that through the lens of equality of opportunity. Conservatives did not really like this because they believed it was the government getting involved in a private business. You know, healthcare is a private business. Also, they believe that individualism, if a person wants to spend that much money on healthcare, they should be able to spend money on healthcare and get better healthcare if they want it. If a person doesn't want to get healthcare, they shouldn't have to. Also, if they can't afford it, they can't afford it, would be their take on it. So I would be able to connect those core values with those ideologies if you're asked about them in an FRQ. Anything else? I'm happy to stay on for a couple more minutes if there's a few more questions. Didn't we go over those polls, Bella? Can I cover how a bill is passed? Yes, I can. So a bill is introduced by any member of Congress, and then it is referred to the appropriate standing committee and then the appropriate subcommittees, right? And in subcommittees, they can mark up the bill, meaning, you know, change it however they want to. They can kill a bill, meaning it dies in committee. They can report on it favorably to the floor. And then in the House, they talk about it with limited debate. And in the Senate, they can talk about it with unlimited debate because that's where the filibuster can take place. And then they vote on it and send it to the other chamber. It has to pass in the exact same version of both chambers before it goes to the president, where the president can sign it. Yay. Veto it. Boo. Ignore it for 10 days and it becomes law without their endorsement. And then if Congress is within 10 days of ending or has ended, 10 days ago, the president can use a pocket veto. Pocket veto cannot be overridden. So that is a pretty big weapon that they have in their arsenal. And then the question is, what do I think is the most forgotten thing on the AP exam consistently? Okay. Kids mess up pocket vetoes and vetoes. They don't think that they're both express powers. They are. Kids mess up executive agreements and executive orders often. Thinking that they're express powers and they're implied, and they confuse the two. Executive agreements are, just think like an agreement between two heads of foreign nations, temporary because it bypasses the Senate. Executive orders have the same force of law, but again, temporary because it bypasses Congress. People mess up the War Powers Act a lot because they don't think it is, they miss up the days, or 48 hours and 60 to 90 days for troop deployment. What else is another good one that people mess up? Let me see. I would know a couple of laws. I would know, or a few. I would know Bipartisan Campaign Reform Act. I would know Controlled Substances Act. I would know the Judiciary Act. I would know the Gun-Free School Zones Act. Civil Rights Act. Hello. I would know those. And then I'm just looking to see other things that people get confused on. I don't know, Allison, why don't you let me think on that one? And I can post something to the announcement section.
Excuse me, Mom?
Yes.
Can we do this?
Can you do what?
Marble.
Marble painting? Yeah, come say hi to everybody. Here, Kaya, say hello. Willow, say hello.
Hi. Hi.
All right, so we're gonna go marble paint inside, guys. Wait 2 minutes, and then yes, we absolutely can. That sounds fun.
Oh, look,
I'm sure you do know how, but
it's a marble painting.
we're about to find out. Oh yeah. Okay. I tell you what, I'm going to think on that, Allison, and I'll post something for you guys and I'll let you know when I do. I have recorded the video for the first 2 FRQ responses to the FRQs I posted in CTLS. I haven't recorded the response for 3 and 4 yet. I'll do that at some point today. If you have any questions, hang out. If you're good, you may go. But pop on your video and give me a wave so I can wave to you and give you a thumbs up and tell you I'm proud of you. Bye, Aditya. Oh, bye, Catherine. I see you. All right, bye, everybody. Bye, Neil. Bye, Anne Claire. Bye, Olivia. Bye, Brandon. Bye, Emily. Bye, Annika. Bye, Arsh. I'm trying so hard. Bye, Allison. Bye, Annika. All right, you stay and put. Do you guys have any questions? Bye, Caleb. Hang on, baby. Annika, Ben, do you guys have any questions? All right, I'm going to stop it then. You guys are awesome. See you later.